Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colony Town Judge Peter Crummey. Welcome to Benchmark. We'll explore a variety of issues involving our justice system, our legal system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to be joined by a distinguished jurist who is also a resident of the town of Colonie. Judge Patrick Monserate previously served as Broome County District Attorney, Broome County County Court Judge, and a Supreme Court Judge of the state of New York. Currently, the judge is serving our legal and justice system here in Albany County. And we're very fortunate to be joined by Judge Monserate today. Welcome, Judge, and thank you for joining us here.
Thank you for having me, Peter.
Well, we're thrilled to have you here, not only on the television show, but also as a resident of the town of Colonie. And Judge, before we were taping, there were so many things that I learned in addition to what I already knew about your very successful background and experience in the justice system. And I was hoping that you would spend a little bit of time telling us about your days as assistant district attorney and district attorney and how you got started in public service on behalf of the justice system.
Well, back in the early 70s, or early 60s, really, I graduated from Albany Law School in 1960, and I went back to Broome County where we raised our 3 girls. And during the early 60s, the district attorney's office in Broome County and in many areas was part-time, so you could be with a firm doing private practice and also with the district attorney's office. And in order to get some trial experience, I went with the district attorney's office as a part-time assistant for 3 years early in my career, and I got the taste for both public service and prosecution, and I found that I enjoyed both. And when the opportunity presented itself late in the 1960s and early 1970s to go back to the district attorney's office on a full-time basis, I did that, and I've never looked back.
Well, Judge, certainly service in the district attorney's office, initially as an assistant district attorney and then as the district attorney, certainly during the 60s, were a very exciting time politically here in the state of New York as well. And you're from Broome County, and of course Warren Anderson and his father too played a very prominent role in Broome County at that time and in the state of New York as time went on. And of course Nelson Rockefeller was also presiding over the state of New York at that time, and I'm sure you had some interaction with both personalities as you were moving into the district attorney's office. And would you tell us about your first appointment as district attorney?
Well, it was in the fall of 1970, and that year was when Broome County first went to a charter form of government, and with an elected county executive, and the county executive was Ed Crawford, who later headed the Association of Counties.
That's right.
And but he was the first county executive, and there was an opening in the district attorney's office, and Ed Crawford felt that the Broome County Charter gave him the authority to appoint the district attorney to fill a vacancy. And of course, Governor Rockefeller, relying on the Constitution of the state of New York, thought he had that authority. And so the office was vacant for a month while the two and their staffs argued about who was going to appoint me. And so one day Ed Crawford called me on the phone and asked me to be in his office the next day at noon because he was going to swear me in as district attorney. On the morning of that day, a nice young trooper state trooper arrived at our office and said he was from Governor Rockefeller, and he handed me a letter from Governor Rockefeller appointing me. So I covered my bets. I put the letter in my pocket and took the oath from Ed Crawford, and that's how I started as district attorney.
Well, it sounds like both men realized that the right choice was the same choice.
Okay.
Well, that's very exciting. Of course, you were district attorney throughout the 70s.
Right.
And one of the largest developments that occurred courtesy of the state legislature and Governor Rockefeller were the Rockefeller drug laws, which are still talked about today. And that probably had some impact on your own duties as the district attorney, and probably impacted your office to some degree. Could you share with us some information about how the Rockefeller drug laws affected your prosecution of cases and handling of cases as a DA?
Well, of course, the 1970s throughout the state of New York was the time when we all had to deal with this drug problem, and it became a problem all over the state because we realized that people were getting on buses at the Port Authority in New York City for the express purpose of coming to our community and many other upstate communities to commit crimes, to sell drugs. And so we realized that we had to deal with that problem, and the governor at that time held hearings and legislative hearings and so forth about changing the laws to deal with the drug problem. And the laws that were enacted in 1973 bore little resemblance to the bills that we had testified about as they worked their way through committees. And the one thing that struck me then, and it's still there 35 years later, was the second felony offender law. And that said that anybody convicted of any, not just drug crimes, any felonies twice within 10 years had to go to state prison, mandatory state prison for a nonviolent crime, cashing 2 or forging 2 checks in 10 years. They had to go to state prison. And that was a dramatic sea change as a prosecutor and later as a judge for being faced with the situation of having to send people to state prison that you honestly believed didn't belong there. And of course, the real problem for us was that we were seeing nonviolent offenders go in the front door of the prisons for no good reason except the law said they had to.
Right.
But we also realized, those of us in law enforcement, was to make room for them, the prison authorities were letting out the back door on earlier parole the violent criminals that deserved to be in prison and deserved to stay in prison. So we were shipping our nonviolent offenders out of Broome County and seeing the violent offenders come back far earlier than we had anticipated. That was a problem throughout the time that it was district attorney and a sentencing judge, and it's still, to my view, a great problem in the law in the state of New York today.
Judge, after your 10 or 11 years as a Broome County district attorney, there came a time when you were asked to run for county court judge. Is that correct?
Right.
And how did you make the transition from district attorney to county court judge?
Well, it was a very easy transition in that I felt I understood the role of the district attorney, and I felt I understood the role of the county court judge. I was no longer district attorney. I could not initiate prosecutions. All I could do was deal with the cases that were brought to me, and I tried to serve in that particular role.
And you served as a Broome County Court judge for approximately 6 or 7 years. Is that?
It was about 9 years.
Yeah, even more than that, 9 years. And then there came a time, of course, when you were selected to serve as a Supreme Court judge.
Right. And that basically was the transition from the criminal side, which I had been working with for about 20 years, to the civil side and trying civil cases. And it expanded my horizons geographically. Instead of working exclusively in Broome County, I worked in the 10 counties of the 6th Judicial District and beyond that, because they were always looking for judges to serve in the busier areas of the state. Westchester, Suffolk County, Nassau, the city of New York, out as far as Buffalo. I've sat in Erie County on a couple of occasions. So,
Well, I know that's true. Back when I was in law school, Judge Larry Cook, who was then the Chief Judge of the Court of Appeals, put me to work in the Office of Court Administration one summer, and I was put on Cook's tour, where we were gathering information at that time from county courthouses throughout the 3rd and 4th judicial districts as to volumes and caseloads, so Judge Cook had a better idea in the coming year or two of where he intended to assign certain Supreme Court judges.
Right.
And of course, I recall a famous case brought by one of the Supreme Court judges from Hamilton County.
okay.
And I went up to visit him one day as part of my duty that summer, drove to his courthouse, and had to go through his files to determine how many cases he had pending, and they had 5 at that particular time, and he liked it like that.
Right.
And soon enough after that, of course, that information was provided to the Office of Court Administration and Judge Cook as well, and he decided that maybe that judge, that Supreme Court judge, could do some time on Long Island, and he commenced an action at that point, a celebrated action against Judge Cook, saying that it was improper and illegal and inappropriate to assign him from where he was elected to another area of the state. And of course, the judiciary decided that no, Judge Cook could reassign, and of course that's very common practice today.
And yeah, and in those early days, I was one of the flags on the map that got assigned around the state, and there was a great deal of resentment among the local judges that what are you doing here? We don't need you, and we're fine the way. So you had to kind of tiptoe around and more do it their way, and they had their way of doing things. And the easier way was to find out what their way was and adapt to their methods of doing things, and you got along much better.
Well, it takes a person who is so dedicated to public service to recognize how to get the job done regardless of the locality you're in, and you obviously were very successful about that. And I think it's very interesting to note, too, in all of the public service, including serving as district attorney, as county court judge, and Supreme Court judge, all of those are elected positions.
Right.
And oftentimes our candidates are engaged in heated campaigns to seek election to any one of those posts over time. And it seems to me that you may have enjoyed cross-endorsement most, if not all the time, regardless of whether it was district attorney or a judgeship. Is that correct, Judge?
Yeah, I ran for either district attorney or a judgeship 6 times, and I was cross-endorsed 5 of the times. Matter of fact, I was not opposed the first time because the Democrats nominated their candidate first. So I was the second one in the race, so I opposed him. But I was cross-endorsed the other 5 times, yeah.
Well, that's obviously a tribute to your own dedication to service. I mean, that just doesn't, that's earned, that type of celebration by all parties that you should serve in that capacity, regardless of the capacity. And I'm very interested in your look and feeling for how caseloads have changed, or the tenor of cases, if you believe they've changed at all, since the 60s, when you started even back in Binghamton as a part-time city court judge, up and through your term as Supreme Court judge.
Well, as in so many other areas of the law, you have to draw a line just above New York City and talk about the way things are in New York City and the way things are upstate New York. And I recognize and sympathize with the people that do the same work I was doing in New York City with their 2,500, 3,000 caseload. And I'm sitting upstate New York doing the same work, and I have 500 cases. So in terms of being a judge in upstate New York, because the areas have been good about recognizing the increase, particularly on the criminal side, they've created more judgeships. The Office of Court Administration is able to assign judges around to fill temporary emergencies and so forth. And so really, as far as upstate is concerned, we always had enough resources to deal with our caseloads, and our caseload never really got out of control. But that's different when you talk about New York City or Long Island. They truly have caseloads that I don't know how they manage them.
Well, it continues in that way, unfortunately, oftentimes when I look out into my own courtroom, I see standing room only, and sometimes, Judge, I feel that that's not a good thing, that so many people are in the courtroom, whether for responding to criminal matters or civil matters. It suggests to me that oftentimes something has broken somewhere, and now the court is often the forum of last resort for so many people, both in civil and criminal matters. Did you see a difference in criminal matters and the reasons for criminal cases from the 60s when you were starting to prosecute as an assistant district attorney through the years you presided over criminal matters as a judge?
I saw a change in terms of the symptoms. In other words, drug cases. When I first started in the district attorney's office, we would go a year without a drug case. By the time we went back in the late 60s, we had nothing else but drug cases. But the cause that I see has remained the same, and that is not giving, as a society, not giving a high enough priority to raising and educating and training our children in secure family environments, in good schools, and some religious training so that they develop their potential as individuals. What you see now are young people who have none of that, and they reach their adolescence and teen years and their youth, and they are under-socialized, undereducated. They have very poor self-esteem. They don't have much self-respect, so therefore they don't respect others. And the stern lecture that I might have given an offender 25 years ago, somebody today probably wouldn't understand what I was talking about.
Well, Judge, you know, I see in my own courtroom that there are a variety of broken situations that have led people into the courthouse, either by invitation or by their own motion. But I was at a one of the things that I find so on point with my own courthouse too is a comment that was made by a representative of OCA to the Office of Court Administration to judges just a few weeks ago during our annual continuing legal education requirements as town judges. And they put forth a figure that that in 1980 there were 20,000 drug cases in the state of New York, or 27,000, excuse me, and now there's over 200,000. And it seems to me to certainly be a big problem in the courthouse when drugs are involved in so many cases. And what that number doesn't include, I assume, are cases where drugs were involved underneath the fact pattern, but there was no drug arrest.
Right. Yeah, the labels jamming the person. Why did they break into the neighbor's home? Why did they forge the check and so forth to get money for drugs? And why did they commit the robbery? The labels changed, but the underlying cause are the drugs.
And this morning in my courthouse, we had an active civil calendar, which included cases involving landlord-tenant matters, building and zoning matters, small claims matters. And I also was joined by students from South Colonie High School. They come on an annual basis to visit one of my civil sections, and then I have an opportunity to speak with them after and answer their questions. And there must have been 25 or so students with their teacher there. And I take the time to talk to them about the impact of drugs on the court system, and that it's actually costing them money. And I routinely ask them how many work, and routinely more than half of the high school students are already working. And I let them know that they're paying for this problem still, and it's not necessarily just okay to say, well, if I don't do crack, I don't care if he does. as long as you don't mind paying for him to do crack,
Right.
because he will be arrested, he will be handled by the police, the court system, he will be evaluated, he will be treated. It may work, it may not, and it's all typically done, oftentimes at taxpayer expense. And I'm trying to get them to understand that it's a financial issue as well, and one in which 18-year-olds will be confronting and have to confront in this growing criminal justice system at the local level. I think the state, as you mentioned before, has thought of ways for jail diversion and backdoor early exits into from their own justice system, which to me puts many of those folks right back here at the county and local level.
Oh,
and we're
yeah.
policing that as well.
Yep.
And our town, of course, of 80,000 people, has 130,000 people in it, Monday through Friday, 9 to 5. So the town residents are not only are having to pay to take care of their own, but also for our visitors, who don't always come with the best intentions.
Right.
As well. And it's been a busy place for us routinely in that way. How do you think the Office of Court Administration has managed? I know it was a concept from the 60s. I think it might have been Governor Rockefeller's idea. I don't know. And a trade to promise the counties that we'll pay for your judges now as long as you give us courthouses. Exactly. How do you think it's all worked?
I think it's uneven. In other words, there are things they've done very well. Obviously, to put judges and district attorneys on the state payroll has taken a financial burden off the localities, and of course that their staffs and so forth. So that's then the theory was that the county would pay to build the new courthouses, enlarge the old ones, and so forth. That's still a struggle to get the counties to. When you talk courts to the county now, they say that's the state's problem, and they forget their half of the deal. But I think the tremendous dichotomy that we work with in the legal system between New York City and upstate has been the problem, because I think the model that OCA is following is very much a New York City model, which may be necessary down there. It may even work down there, but it's different than the way we have traditionally practiced law and adjudicated cases in upstate New York. And I still think that we can do things differently and better in upstate New York, because we don't have the number crunch that they do in the city. And I think it's a mistake to try and standardize everything and base it on a New York City model. It may or may not work in New York City, I don't know. But I know from experience what works upstate, and I think that many of the rules that are promulgated by OCA we don't need, because everybody behaves themselves better in upstate, the typical upstate court, than they may in the city. But again, we have smaller caseloads and we have fewer problems to deal with.
Right.
So, but I think they've done some good things, and I don't know when they're going to stop. I mean, everything doesn't need changing, but I think they see that if something is the same as was yesterday, it better be different tomorrow, or they are doing their job, which is not necessarily true.
Well, Judge, we've spoken a little bit about changing trends in the criminal law that you might have seen over time. You were in private practice as well, and also served at least 14 years as a Supreme Court judge. Any changing trends in civil matters that you saw from your early days to serving as a Supreme Court judge?
Well, of course, there is I won't say an eagerness to sue on the part of the average individual, but there's certainly a willingness to sue. And I think lawsuits are more prevalent. I think they are of a different type. It doesn't, we've gone from the obvious people being injured physically to people injured emotionally or their psyche, and no blood, no scars, but the injuries are real and the lawsuits are real. And I think we have much more of the lawsuits dealing with people either real or imagined hurt feelings, and they, I think 10 years ago, the thought of suing somebody because they were insensitive didn't occur to anyone. But we now have a whole body of law that really talks about, really at the base of it is insensitivity.
Judge, I currently serve as a director of the Albany County Bar Association, and routinely we discuss attorney behavior with each other and collegiality with attorneys, and some suggest that that is a bygone relationship, that bar associations and the members of the bar were much friendlier many years ago and worked things out, and now it's more difficult and strained relations and pit bull mentality. And I wondered if you saw any of that change, or whether you recognized there was really any problem there.
Well, again, the war stories that I hear from other judges and other lawyers tend to be grounded in New York City and Long Island, where they do things differently, where the pressures are different. And we still, in upstate New York, I feel, do business on a handshake, on one's word. I know I've tried lawsuits with a lot of lawyers, and I've made decisions based on their word, and I have never been disappointed. In other words, I've never had a lawyer lie to me on a case in upstate New York, and I think that the collegiality is there. I think the one thing we have to pay attention to as a profession is that, as you know, a person can legally go to law school, pass the bar, have a certificate, and can walk into any courtroom and try a case. I think we have to do more about advising, educating the public that there are lawyers in the profession by reason of education, training, experience that are more qualified than others. The people are free to take their pick. But I think we as a profession, either through certification or some other means, have to, I think, fulfill our responsibility and letting the public know that there are lawyers that, by reason of their education and training experience, are qualified to do certain things, criminal defense or med-mal plaintiff's cases and so forth like that. Because I think left to their own devices, and they're going to hire the lawyer perhaps that they last saw on the infomercial or the billboard or the back of the bus, and they may not be the best people to represent them.
Well, Judge, of course, part of serving as a judge is maintaining demeanor and decorum in the courtroom, and one of the instruments that's often provided to a court and a judge is a gavel, and I think that you've had an interesting story for us about using a gavel in the courtroom, and I'd hope you'd share it with us.
Okay. It was my first morning as a judge. It was in January of 1981, and I was in Suffolk County, which is out at the tip of Long Island, which was a wonderful place to be in June, July, and August, and not so good in January, which is why I was there. And I was assigned there to hear civil cases, and my directions said the court would start at 9:30. So at 9:30, I put on my robe and walked out and was greeted by an empty courtroom. The only person in the courtroom was a court clerk who was reading the daily news. He had his jacket off, and he looked over his shoulder, and he says, "Can I help you?" And I said, "Well, I'm the judge that's supposed to preside in this case today." And he said, "Well," he says, "you're early." He said, "Why don't you go back and I'll call you when we're ready to proceed." And I looked at the bench and I didn't see a gavel. So I said, "Where's the gavel?" And he looked at me and he says, "Young man, if you need a hammer to keep order in your courtroom, you don't belong up there," and went back to his daily news. Best advice I had.
Judge, you're so busy now today with so many things continuing on with your efforts in the justice system. What are you doing now, Judge?
Well, now I'm serving as a judicial hearing officer, which means that I can be assigned with the consent of the parties to preside over trials, much as I did before, and I'm authorized to do that in the 3rd District, which is Albany, the 4th District, which is Saratoga and Schenectady and to the north, and my home district, the 6th District down in Binghamton. So I do that, and then I'm also involved in doing private mediation, trying to resolve lawsuits before they get to trial, which is something I did as a judge, and something I'm enjoying continuing to do to reach a fair resolution for the case without putting the parties through the stress and expense of the trial.
Well, you've certainly excelled, Judge, on behalf of the legal system throughout your professional career and continuing on even to today. And I want to thank you very much for joining us today and being with us.
Thank you, Peter.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.